and voting on two bills. The one I'd like to start with is Delegate Spiegel's MC 1125, which is a bill that deals with common ownership communities. And we did discuss this last week, but if anybody has any questions about this bill, it is a long one, but it's not as long as it looks. Because it's three identical sections relating to HOAs, condominiums, and co-ops. Is that right? So it ends up being a lot of pages, but it's really three times the same thing. And Delegate Spiegel has a couple of amendments that he would like to offer. Amanda, are you able to show us those amendments? And perhaps Delegate Spiegel could just talk us through what he'd like to do.
Yeah, I have two monitors, so let me try and share my screen.
And you should have permission to share screen as well.
Okay, give me 2 seconds. Let me pull it up. I don't have any interlineated copies. I just have the directional language.
Okay.
Can you guys see that?
Yes.
Okay. I'll let Delegate take it away.
Thank you. Madam Chair, with your permission, I'll walk through these.
Please.
Thank you. We received written testimony, which is in the record, from Thomas Allen with a number of helpful suggestions on some technical clarifying amendments and cleanup language, just to make sure that the language of the original draft was tweaked to reflect the intent of the bill. What you see before you is essentially four concepts rolled into one large single amendment, and I'll just walk through those concepts really quickly. The first one basically makes sure that the provision that prevents an HOA or condo association from imposing its own incurred legal fees on the unit owner who might be in a dispute with it until and unless there is actually a final adjudication of their dispute. We wanted to make it clear that we were only referring to collection of the association's legal fees from that unit owner who is currently actively engaged in a dispute. So, for example, we didn't want anyone to misinterpret this as saying that the association couldn't collect money to use for its own legal fees from any unit owner in the community. Obviously, it should be allowed to continue collecting dues and using a portion of those dues reasonably for the reasonable legal services needed by the association. So that's the first one. The second one is to make sure that we are referring, when we refer to fees awarded against a unit owner, that in the final adjudication of a dispute between a unit owner and an association, can only be awarded against that unit owner, or they can be awarded earlier, but they can only be collected against that unit owner after appeals have been exhausted. So normally what you would see, for those of you familiar with civil litigation matters, is a fee award might be ordered by a trial level judge, but the parties might appeal. So the award can stand, but the collection of that award against a unit owner would wait until all the appeals have been exhausted, if there are going to be any timely appeals. And that's to prevent a unit owner from having to pay some very significant amount of money that might end up getting reversed on appeal. So we wait till the appeal is over. And so that's just clarifying language for that section of the bill. The third piece of this sort of omnibus amendment makes clear that parties who otherwise have a conflict of interest and should not be permitted to act as the judge or adjudicator over a dispute includes not only somebody who is a member of the governing body or an officer of the governing body, if the governing body itself is also a party to the dispute. It's like saying, if somebody sues a judge, that judge can't preside over that case because they're a party to the case. We also added, to make it clear, that the person acting as the internal judge, if you will, in an administrative proceeding within an HOA under its bylaws cannot be an agent or representative of that person who has a conflict of interest or a family member of that person who has a conflict of interest, just to make it clear. So there's no end run around that conflict of interest rule. And then finally, we just wanted to make sure that in case there's any differentiation between some of the relief available in this bill and some of the relief otherwise available in other provisions of the state code under the real property code, for example, that nothing in the real property code would prevent a judge or an arbitrator from issuing a ruling if they felt it was appropriate based on the facts and the circumstances that would allow for the relief set forth in this bill. And so those are the amendments. Again, they were suggested largely by Mr. Allen in his written testimony, and we wanted to accommodate them. We thought they made sense. Happy to answer any questions. Thank you, Madam Chair.
Thank you. Delegate Shetty.
Thank you, Chair Ziegler, and thank you, Delegate Spiegel, for this bill. I think many of us have a lot of HOAs and common ownership communities in our districts, and we certainly follow a lot of listservs where there's lots of grumbling across the board when there are disputes of these types of nature. And so I'm glad to see a well thought out, thoughtful approach to how we could address some of these broad concerns. I wanted to ask, and I apologize if this was discussed in a prior subcommittee meeting, but I wanted to ask if you had any further definition or clarification on the term conflict of interest, like for the provision specifically around the independent party who can run the elections. I see you've kind of defined it in some of parts with your omnibus amendment, but I'm just curious if you have thoughts on what constitutes a conflict of interest. Is being their neighbor, going to a barbecue at their house, what is it financial, is et cetera? And are you envisioning in the election piece in particular that HOAs would have to hire an attorney or an independent firm or something to run these, or can they still run them, as they typically do from other neighbors volunteering to be there? And if so, who would be considered to be conflicted out?
Thank you for that question, Delegate Shetty. A great question. There are actually two separate provisions that sort of implicate the idea, the concept of a conflict of interest here. One provision is in case there is a sort of quasi-judicial proceeding under the bylaws of an HOA where a dispute before it ever gets to court is being heard internally by the HOA itself to ensure that if the HOA is a party to that dispute, in other words, the unit owner is challenging something that the HOA itself is doing, that the HOA's own officers and boards and their relatives and agents can't serve as the judge in that little sort of internal proceeding. So that's one conflict of interest piece. And we didn't, we tried to really avoid any sort of vague references to conflict of interest and instead tried to be very specific in how we define who's eligible and who's ineligible in that situation. I think the section you're referring to is regarding how elections are conducted. And the idea here, of course, is, without disparaging any particular HOA leaders. There are many, many very well-run HOAs and condo associations and co-ops. This is really intended to avoid the most egregious problems that we see in some HOAs and condo associations with respect to elections and election transparency, since so much is at stake for the unit owners. In most cases, this is the largest investment they'll ever make in their lives. This is their home. And we want to make sure that those proceedings are fair, that there's accountability and that there's transparency. So that separate section regarding elections also does not use a broad, vague reference to conflict of interest and just, defer to everybody else to figure out what conflict of interest means. Instead, it offers a very clear definition of who can and who can't serve as the person collecting, counting, and confirming the votes in a board election for the HOA. So it does not use that general vague term conflict of interest all by itself. It defines who cannot, But to your point, we wanted to make sure that this wasn't a situation where we were forcing associations to have to hire a third party and pay a bunch of money. So there is a provision in the bill that says as long as somebody is not running for a board seat themselves or is not openly and actively working to support or oppose a particular candidate for a board seat, then that unit owner who is a member of that association can be the one to conduct the election. So the association could appoint someone to be their internal election monitor, election manager, whatever you want to call it, on a volunteer basis within the association, who would not have to be paid and would not have to be a separate third party, if that makes sense.
Yes, Madam Chair, may I just do a quick follow-up specifically on the language I had a question about?
Sure.
Thank you, ma'am. Page 28 of the bill, and I don't know if this was amended in the amendments that you have before us. Page 28, lines 23 through 24 of the version posted on the Montgomery County delegation site says subsection B, subsection 2, right? Elections for the governing body of a homeowners association, blah, 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 shall be conducted by independent parties who do not have a conflict of interest regarding any candidate. That's the section. I was just curious if you had defined those terms of what does that mean to not have a conflict of interest?
Yeah. My understanding was that the intent and the meaning of that section was to be read sort of holistically with the first provision that talked about not being candidates on the governing body. But I would welcome if there's an amendment, being considered to clarify that language. I understand where you're coming from there now that I see that clause is there. I think the intent was to have it be clear that it was not somebody who was either running as a candidate or acting as sort of an agent of a candidate by virtue of actively working to oppose or support a particular candidate.
Oh, I see. We're in the, yes, I apologize. So I see in subsection 2, it defines folks that are deemed an independent party. And so that means they do not have a conflict of interest.
Correct. Right.
Okay. I'm wondering if we might just be able, I mean, I don't know. I appreciate the clarification. Thank you. I'll stop asking questions. Thank you.
No. I mean, that's exactly right. So if you look at it holistically,
Yes,
I think you're looking now at page 29,
that's right.
lines 1 through 7, includes a provision at 2 sub 2 that basically says you're deemed an independent party if you do not electioneer for any candidate.
Yes. Okay. Thank you. I appreciate the clarification. Thank you, Delegate.
Thank you for the
Delegate
question.
Sorry, Delegate Cullison. You're muted.
Here, it was so eloquent. Delegate Spiegel, the amendments that you're suggesting, have you run those by representatives of homeowners association? Are these amendments that they were looking for, or were they more legal in nature? And if they don't know about them, should we be running them by the homeowners association's representatives?
Fair question, Delegate. Thank you for that. These came from written testimony that was submitted from the public hearing back in December. So we basically just plucked them out of that. I mean, to the extent that it's in the written testimony in the record and people can see it, I guess there's notice from back in December that there was an advocate asking for these amendments. But we have not, had any formal meetings with HOA or condo associations. To be honest with you, there haven't been organized efforts by representatives of multiple condo and association organizations, trade associations, to discuss the bill with us. We have had the occasional individual email here and there from 1 or 2 HOA presidents, but we have not had formal conversations about these amendments. So just want to be
and-
honest about that. That's
Yeah,
where things
yeah.
stand right now.
No, and I don't have any specific concerns about the amendments. I was just know from some experience with some HOAs in District 19, they sometimes are saying our rules for them are hard to manage, and that's why I was wondering if there's been that kind of feedback. But to me, it feels like these are like actually making the rules a little simpler to follow. I mean, I know it's a long bill and a complicated language, but it seems like the intent is to simplify and make clear to them about, some aspects of their business.
Thank you, Delegate. And I would go even further to say that one or two of the portions of this amendment are actually designed to protect the association a little bit better, and make it clear that the language shouldn't be interpreted in a way to create significant problems for the association with respect to, for example, being able to collect dues and fees on a regular basis and then use some portion of its budget for legal guidance and advice as needed for the association itself. So that's part of the amendment as well.
Right. Thank you very much. I appreciate it.
Thank you.
Is there any more discussion? Any more questions? Seeing none, thank you very much, Delegate Spiegel, for coming to our subcommittee twice, and I appreciate that. Do we feel ready to take a vote on this bill?
Yes,
Yes.
And if so, do I hear a motion?
I'd like to move the amendments, Madam Chair.
I'll second.
Thank you. I guess we do a roll call, is that right? Delegate Shetty?
Aye.
Delegate Charkoudian?
Yes,
Delegate Cullison?
Yes.
And I'm also yes.
I'd like to move the bill as amended.
Second.
Okay. Delegate Shetty?
Yes.
Delegate Charkoudian?
Yes,
Delegate Cullison?
Yes.
And I'm a yes. Thank you very much. So we are waiting for Delegate Kaufman, who will be joining us very shortly, hopefully along with Delegate Crutchfield. And at that point, I'm just going to give it another minute or two. Otherwise, I think we can move on to MC9, which is ranked choice voting.
Madam Chair, with your permission, I'll depart the Zoom, but I want to say thanks to all of you
Absolutely.
very much for your good questions and your support.
Thank you. Delegate Kaufman texted me a few minutes ago saying that he would be there in a minute. So,
can I ask a question, Madam Chair?
oh, please.
I feel ready to vote on Delegate Kaufman's bill without him being here. I would move it and vote for it. I don't know if there's folks who feel like he needs to be here to answer questions, but if not, I think we can move it even if he's not able to make it.
Yes. Second.
So then I'll move the bill.
Second.
Thank you. Okay. Delegate Shetty,
Yes.
Delegate Charkoudian,
Yes,
Delegate Cullison,
Yes.
and I'm a yes. Wonderful. We've ticked off 2 of our bills. So I will text the others, and with that, we are adjourned.
Thank you, Madam
Thank
Chair.
you.
Madam Chair.
Thank
you.
you very
Bye.